Hi everyone, welcome again to the series of lectures on property and land laws. Our topic for today is prescription. Okay. Prescription is of two kinds. Okay. We have acquisitive as well as extinctive prescription. Okay. What is prescription? Okay. Article 1106 states that by prescription, one acquires ownership and other real rights through the lapse of time in the manner and under the conditions laid down by law. So in the same manner, rights and actions are lost by prescription. So prescription is like a coin that has two sides. It can be a manner of acquisition or a mode of acquisition. It can also be a means by which you lose a certain property or a certain right. Okay. Now, who are the persons who are capable of acquiring through prescription? So we are talking here of acquisitive prescription. Okay. Of course, persons who are capable of acquiring property or rights through other legal modes may also acquire through prescription. So if you are able to acquire properties or rights through contracts or through for example, through sale, through donation, okay, uh, then you are also capable of acquiring rights or properties through prescription. Okay. How about minors? Minors and other incapacitated persons may acquire property or rights by prescription either personally or through their parents, guardians, or legal representatives. So with respect to minors, they act through their parents, guardians, or legal representatives. So uh, we now proceed to the things which are capable of being acquired through prescription because we already know the persons who are capable of acquiring through prescription. Now, what are the things or rights which are capable of being acquired through prescription? Article 1113 tells us that all things which are within the commerce of men are susceptible of prescription unless otherwise provided. Property of the state or any of its subdivisions not patrimonial in character will not be the object of prescription. So as long as the property or the right is within the commerce of men, they are capable of being acquired through prescription. However, those which are outside the commerce of men, such as properties of public dominion, okay, owned by the state, is not capable of being acquired through prescription for the obvious reason that it is needed for public use or for the development of the national wealth. Okay. Prescription, as I've said, is both a means of acquisition or loss of ownership through the mere lapse of time. As we have mentioned a while ago, they are of two kinds, acquisitive as well as extinctive. Acquisitive prescription is the acquisition of ownership and other real rights in the manner and under the conditions provided by law, while extinctive prescription is the loss or extinguishment of property rights or actions through possession by another of a thing for a period provided by law or through failure to bring the necessary action to enforce one's right within the period fixed by law. What is the basis of prescription? In several cases, the Supreme Court has ruled that prescription is a statute of repose, whose object is to suppress fraudulent and stale claims from springing up at great distances of time. There is an end to everything. Litigation must end at some point in time. That is the reason why the law um, finds it necessary to have prescription as a mode of extinguishing certain rights or obligations. Okay? Because fraudulent and stale claims must not be instituted at a very in a very late manner. Okay, now what is the capacity to acquire through prescription? As I've said, as long as you are capable of acquiring through other modes of acquisition of ownership, you can also acquire through prescription. Okay, with respect to minors and incapacitated persons, they may be able to acquire through prescription through their guardians or legal representatives. Article 1108 states that prescription, both acquisitive and extinctive, run against minors and other incapacitated persons who have parents, guardians, or legal representatives. Absentees who have administrators either appointed by them before their absence or appointed by the courts. Persons living abroad who have managers or administrators, and juridical persons except the state and its subdivisions. So you must remember that all these persons that are mentioned, okay, are capable of acquiring through other modes of acquisition of ownership. Okay, they may do so even though they are not of age or that they are absent, okay, in our jurisdiction, as long as they have managers, administrators, okay, they are capable of acquiring as well as losing property through prescription. Okay, it must be mentioned that the juridical persons excludes the state and its subdivisions. Prescription does not run against the state. Okay, Article 1110 states that prescription, acquisitive, and extinctive runs in favor of or against a married woman. Now, who are the persons against whom prescription does not run? Okay. Prescription does not run between husband and wife, even though there be separation of property agreed upon in the marriage settlements or by judicial decree. You must remember that with respect to spouses, they are treated as one entity. Okay, so if, for example, the property of a spouse, okay, has been occupied, okay, in the period of time required by law and in the manner which is imposed by law, okay, and it is owned by the other spouse, prescription does not run. Okay, why? Because they are treated as one and the same entity. In addition, prescription does not run against the state and its political subdivisions with respect to properties of public dominion. You cannot acquire properties of public dominion. Why? Because it is needed for public use or for the development of national wealth. So prescription runs against the state with respect to patrimonial property. But with respect to properties of public dominion, prescription will not run against the state. Okay? Also, prescription does not run against properties covered by the torrent system. So if it is a property which is already registered under the torrent system, under PD 1529, okay, even if you have occupied the said property in the manner provided by law and within the period required for acquisitive prescription, you cannot acquire it through prescription if the property is already covered by the torrent system. Okay? How about co-owners? Does prescription run against co-owners? So we must remember that prescription obtained by a co-proprietor or a co-owner shall benefit the others. But with respect to the co-owners themselves, prescription does not run. Okay, but with respect to properties of third persons and one of the co-owners have occupied it in the manner and within the period required by law, then that prescription shall benefit the other co-owners. Can prescription be renounced? Okay, Article 11:12 tells us that persons with capacity to alienate property may renounce prescription already obtained but not the right to prescribe in the future. You must remember that with respect to acquisitive prescription, for example, you have already obtained uh, the ownership of a certain property through acquisitive prescription. You may renounce it, okay, but not the right to prescribe in the future. Why? Because it is already a right, okay, and rights may be waived unless, of course, the waiver is contrary to law. Okay. Prescription is deemed to have been tacitly renounced when the renunciation uh, which imply the abandonment of the right acquired. Creditors and all other persons interested in making the prescription effective may avail themselves thereof, notwithstanding the express or tacit renunciation by the debtor or proprietor. So, just like donation, okay, creditors who are interested in making the prescription effective, okay, can avail themselves of the said prescription which was already obtained by the debtor, even if the same has been expressly or tacitly renounced by the debtor. Requisites. What are the requirements for renunciation to be valid or effective? Okay, first, there must be the capacity to dispose property by the person renounced. Okay, and there must be the subject of renunciation must be prescription already obtained because you cannot renounce future prescription. And renunciation must not prejudice the rights of creditors or third persons who are interested in making the prescription effective. And I should perhaps add that the renunciation must not be contrary to law, morals, public order, or public policy. Because prescription is a right, and rights may be waived unless it is contrary to law, morals, public order, or public policy. As I've said, there are two kinds of renunciation. The express renunciation, meaning that there is an explicit declaration or statement of renunciation, and the implied or tacit renunciation, meaning the renunciation is not expressed in statements or words but can be deduced from the acts of the person renouncing. Okay. There is, of course, a prohibition to renounce future prescription, just like future support. Okay? You cannot renounce the right to prescribe in the future. Why is there such a prohibition? It was established because the waiver is contrary to public policy. Akin to the prohibition against renunciation of future support and legitimate, future prescription can also not be waived. Okay. Now, the reason why we have prescription has been expressed by the Supreme Court in the case of Ochagavia versus Court of Appeals. So in this case, the spouses Garban owned several lots. Sometime in they conveyed both lots to Dionisio by way of sale, compacto de retro, and then subsequently, petitioners claiming to be the legal heirs of the Garban spouses filed a case against the respondent who are the legal heirs of Dionisio, questioning the nature of the contract entered into in 1926 and asserted that it was not a true sale with pacto de retro but only an equitable mortgage. Okay, the Supreme Court said the right to redeem should have been exercised at the latest within 10 years reckoned from the execution of the contract. We agree with the respondent that the right to redeem anchored on the sale with pacto de retro has definitely prescribed when the petitioners initiated the civil case more than 6 decades later. Okay, and the Supreme Court went on to pronounce the reason behind prescription. Prescription is rightly regarded as a statute of repose whose object is to suppress fraudulent and stale claims from springing up at great distances of time and surprising the parties or their representatives when the facts have become obscure from the lapse of time or the defective memory or death or removal of witnesses. Our laws do not favor property rights hanging in the air, uncertain over a long span of time. Okay? We also have the case of DBP versus Adil. So in this case, confessor obtained an agricultural loan from DBP. As the obligation remained unpaid even after the lapse of the 10-year period, confessor executed a second promissory note, expressly acknowledging and promising to pay the same on or before a certain date. There is no doubt that prescription has already set in with respect to the first promissory note of February 1940. However, when the respondent executed the second promissory note in April of 1961, where he promised to pay the amount covered by the previous promissory note, and upon failure to do so, agreed to the foreclosure of mortgage, the respondent effectively and expressly renounced and waived his right to the prescription of the action covering the first promissory note. A new promise to pay the debt that is considered as a new promise to pay the debt. The consideration of the new promissory note is the pre-existing obligation under the first promissory note. So the statutory limitation bars the remedy but does not discharge the debt. Acquisitive prescription. We now go to acquisitive prescription. What is the manner by which you can acquire property or rights through acquisitive prescription? The answer would be it would depend on the kind of property that you want to acquire. Is it a real or a personal property? The period of time needed as well as the manner of possession needed would be different, okay, with respect to real as well as personal property. Okay, Article 1117 tells us acquisitive prescription of dominion and other real rights may be ordinary or extraordinary. So with respect to ordinary acquisitive prescription, it requires possession of things in good faith and with just title. So there must be a requirement of good faith as well as just title. What constitutes good faith and what is meant by just title will be discussed in the succeeding slides. Now, ownership and other real rights over immovable properties are acquired by ordinary prescription through possession of 10 years. So you must remember that if in case of ordinary acquisitive prescription, the period of time that is required for you to be able to acquire certain property has to be 10 years. Okay? With respect to extraordinary acquisitive prescription of real property, the period of time required is 30 years regardless of just title or good faith. Okay, so only the lapse of the period of 30 years is required for extraordinary acquisitive prescription. Just title as well as good faith is required only for ordinary acquisitive prescription, whereas shorter period of 10 years would be sufficient to acquire ownership of immovable property. Now, how do you compute the time? How do you compute the 10 years or the 30 years as the case may be? Okay, we now impose the following rules relative to the computation of time. Okay, first, the present possessor may complete the period necessary for prescription by packing his possession to that of his grantor or predecessor in interest. So when we compute time, we do not only compute the time when the present possessor uh, has stayed on the property. So you can also add to your period of possession the possession of your predecessor from whom you have acquired the said immovable property. So if the seller, for example, has stayed in the property, let us say for a period of 10 years, okay? And then the present possessor has stayed in the property for a period of 20 years. Then extraordinary acquisitive prescription can already set in. Number two, it is presumed that the present possessor, who was also the possessor at the previous time, has continued to be in possession during the intervening time unless there is proof to the contrary. So there is continuity of possession. So the presumption is the possession is always continuous. There is no interruption. Whoever alleges the interruption must prove that. Okay, must prove that the possession has been interrupted. Okay, and the first day shall be excluded and the last day included. Okay, so those are the rules in computing the period of time for prescription, acquisitive prescription. How about possession in wartime? Are they counted? The answer is no. Possession in wartime when the civil courts are not open shall not be counted in favor of the adverse claim. So if there was wartime, for example, which lasted for 3 years, those 3-year periods shall not be counted in favor of the adverse claim. Okay, so we have already finished discussing the period of time required for acquisition of real property. Now, what is the manner of possession that is required to vest ownership through acquisitive prescription? So it is not merely the lapse of time, but possession in good faith with just title with respect to ordinary prescription. Okay? And in all kinds of possession, whether ordinary or extraordinary, the possession has to be in the concept of an owner, public, open, uninterrupted. Okay? It has to be in the concept of an owner, public, peaceful, and uninterrupted. Okay? How about those which are possession which is by mere tolerance? Can they be counted as in favor of prescription? The answer is no, because it negates the possession in the concept of owner requirement. Okay, when you say possession by mere tolerance, it means that you are recognizing ownership in another person. So it can hardly qualify as possession in the concept of an owner. That is why Article 1119 tells us that acts of possessory character executed in virtue of a license or by mere tolerance of the owner shall not be available for the purpose of possession. Okay, so the first requirement for acquisition of property, of real property, is that the possession has to be in the concept of an owner, public, peaceful, and uninterrupted. Okay? Possession in the concept of holder will not ripen into ownership through prescription no matter how long it may be. So what is possession in the concept of holder? Example, you are simply leasing the property. If you are simply leasing the property, you are recognizing the ownership in another person. So even if you have stayed in the property as a lessee for a period of, let us say, 50 years, that is not sufficient to acquire said property through prescription. Also, possession cannot be acquired through force and or intimidation. Okay, because of the requirement that possession has to be peaceful. Okay, you cannot wrest possession from another person through force and or intimidation. Okay, it must be continuous for the period fixed by law, depending on the good or bad faith of the possessor. Remember the presumption that on the continuity of possession. Okay, now the burden of proof is upon the person claiming ownership through prescription to show through evidence the existence of the foregoing requirements. So whoever is alleging that he has acquired the said property through prescription, okay, must be able to produce proof that the possession is in concept of owner, public, peaceful, and interrupted for the period required by law. Okay. Now, when do you say that possession has been interrupted? A possession is interrupted for the purpose of prescription, either naturally or civilly. When you say naturally, you are ousted of possession for any cause. Okay? Civil interruption means the service of judicial summons. Okay, that is civil interruption. So once these things happen, okay, the possession is interrupted. Okay, possession is naturally interrupted when through any cause it should cease for more than 1 week. So there is a period for possession to be considered as interrupted. So the interruption must be for a period of more than 1 year. Okay, the old possession is not revived if a new possession is exercised by the same adverse claimant. So the period has to start again. Okay. If the natural interruption is for 1 year or less, the time elapsed shall be counted in favor of the prescription. So if it is 1 year or less, the possession will not be deemed or considered as interrupted. As I've said, civil interruption is through judicial summons. Okay, the judicial summons will not be deemed shall not give rise to interruption if it is void for lack of legal solemnities. If the plaintiff should desist from the complaint or should allow the proceedings to lapse, or if the possessor should be absolved from the complaint. In all these cases, the period of interruption shall be counted in favor of the prescription. Any express or tacit recognition which the possessor may make of the owner's right also interrupts possession. Okay, now we go to possession in good faith and with just title. Okay. The good faith and just title refers to ordinary acquisitive prescription. So with respect to ordinary acquisitive prescription, it is not only the lapse of time for the period of 10 years, it is not only the possession in the concept of owner, public, peaceful, and uninterrupted, but it should also be accompanied by good faith as well as just title. What is good faith? Good faith has been defined in Article 1127 as the reasonable belief from whom he received the thing was the owner thereof. It is a reasonable belief that the person from whom he received the thing was the owner thereof and could transmit his ownership. In other words, you have no doubt that the person who transferred or sold or assign the property to you is the owner of the thing and therefore can transmit ownership. Okay. For the purpose of prescription, there is just title when the adverse claimant came into possession of the property through one of the modes recognized by law for the acquisition of ownership or other real rights. But the grantor was not the owner or could not transmit any right. So when we speak of just title, we are speaking of the mode for transferring ownership. So it could be through sale, which is the most common, all the modes of transferring ownership. Or it could be through donation, or it could be through succession. Okay? So it is through one of the modes of acquisition of ownership. Even if the person who transferred it to you is not really the owner and therefore could not transmit any right. Okay. So when we speak of good faith, okay, there is no doubt on the part of the person acquiring the property that the person who transferred the property to him is the owner. With respect to just title, it refers to the mode of acquisition, meaning it is either through sale, through donation, through succession, or any other mode of acquisition, even if the person who transferred the property to you is not the owner and therefore could not transmit any right. Okay. So the title for prescription must be true and valid. A just title must be proved. It is never presumed. So whoever alleges acquisition through prescription, okay, through ordinary prescription, must be able to prove not only the period of time required by law, not only the possession in the concept of owner, but also the possession in good faith and with just title. Okay. Now, what are the requirements of just title for prescription? So the basis of the possession came from any of the modes of acquisition of ownership, such as sale, donation, succession. The title must be true. The contract must not be simulated or fictitious, and the title must be valid. It must not be prohibited by law. So we have finished acquisition of through prescription of real properties, okay, ordinary as well as extraordinary. The possession must be in the concept of owner, public, peaceful, uninterrupted. If it is through ordinary possession, it must be accompanied by just title as well as faith. If it is extraordinary possession, the mere lapse of time of 30 years would be sufficient to vest ownership through prescription. Okay, now we go to acquisitive prescription of movables. Okay, so the ownership of movables prescribed through an interrupted possession for a period of 4 years in good faith. Okay, so this is now the equivalent of ordinary possession, ordinary acquisitive prescription in movable. So possession of 4 years in good faith. Okay, the ownership of personal property also prescribes through an interrupted possession for 8 years without need of any other condition. So with respect to extraordinary possession, acquisitive prescription of movable. So it refers to an interrupted possession for a period of 8 years. Okay? Movables possessed through a crime can never be acquired through prescription by the offender. So remember that whenever you came into possession of a movable through a crime such as theft or robbery, okay, such possession can never ripen to ownership through prescription no matter how long the possession may be. Okay. Under Article 559, the possession of a movable acquired in good faith is equivalent to title. However, as to movables which were lost, it may be recovered from the person in possession thereof. The finding of a movable which is not treasure and the keeping of the same constitutes theft, and the owner thereof can recover the thing from the possessor because the latter cannot acquire the same through prescription. If the finder surrenders it to the mayor and no one claimed the same after 6 months, he becomes the owner thereof, not through prescription, but by law, because the law provides for it. Okay. Now we now go to prescription of action. So it is now the other side of the coin. You lose property or rights through prescription. Okay. Article 1139 tells us that actions prescribed by the mere lapse of time. Prescription of actions or limitation of actions implies that actions to enforce or preserve a right or claim must be brought within a certain period of time. So the prescription of actions refers only to civil actions and not criminal actions, because the prescription of criminal actions is dealt with in criminal procedure. Okay, so in the civil code, we refer only to prescriptions of civil actions. Okay, so the time of prescription for all kinds of actions, when there is no special provision, shall be counted from the day they may be brought. Okay, so it is always the beginning of prescription of action. So you can bring it to court, but you did not do so. Okay, that is the beginning of the prescription of action. The period during which the obligee was prevented by a fortuitous event from enforcing his right is not reckoned against him. So during said period, the prescription, the period is suspended. The period for prescription of action is suspended because the fortuitous event prevented the person from enforcing his right or filing the needed action. Okay, so the prescription of action is interrupted when they are filed before the court, when there is a written extrajudicial demand by the creditors, and when there is any written acknowledgement of the debt by the debtor. So the happening of these events will interrupt, meaning it will toll the period for prescription of actions. Okay? When it is already filed in court, when there is an extrajudicial demand which is made by the creditor, and when there is a written acknowledgement of the debt by the debtor. So it is the legal possibility of bringing the action which is the starting point for computing the period of prescription. Okay. We now go to the case of MRDC versus Matusco. So in this case, MRDC constructed a condominium. Okay. Now, Multi-Realty executed a deed of transfer in favor of Matusco over these common areas. Okay, so there are common areas. So the developer transferred this to Matusco. MRDC asked that their executives be allowed to park their cars in the remaining 72 allocated parking slots, but it was denied. So MRDC filed a complaint against Matusco for damages and or reformation of instrument. Multi-Realty averred that Matusco's counterclaim was already prescribed because it was filed only in 1990, long after the period has lapsed in 1981. Now, the issue is whether the petitioner's action had already prescribed when it was filed in 1990. The respondent contended that the prescriptive period to file its complaint commenced in 1975 upon the execution of the master deed. Considering that the action was filed only in 1990, the same has already prescribed. Remember that Article 1144 of the Civil Code provides that an action upon a written contract must be brought within 10 years from the time that the right of action ends. The time for prescription of all actions when there is no special provision which ordains otherwise shall be counted from the day that they may be brought. It is the legal possibility of bringing the action that determines the starting point for the computation of the period of prescription. In this case, before the petitioner became aware of the respondent's denial of its rights under their contract, petitioner could not be expected to file an action for the reformation of the master deed. Respondent assailed petitioner's ownership only in 1989 and claimed ownership of the said parking slots, and it was then that the petitioner discovered the error in the master deed. The dispute over the ownership of the parking slots ensued. It was only then that the petitioner's cause of action for reformation accrued. Since petitioner filed its complaint in 1990, the prescriptive period has not yet elapsed. Okay, so it is not the execution of the contract, but the denial. Okay, the denial of their right to the said parking slots. And it was then at that time that they discovered that there is something wrong in the deed. So they asked for the reformation of the contract. So it is only then when the 10-year period, okay, is counted. Okay, so when they file the case, it is still within the prescriptive period and the prescription has not yet set in. Okay, so we now go to the case of OCA versus Court of Appeals. So in this case, OCA executed a general loan and collateral agreement with Planters Bank. Subsequently, there was a resolution passed by the Board of Directors of OCA Lending authorizing OCA to consolidate all the credit accommodations extended by the bank to OCA. So the lot in Manila was foreclosed and was awarded to the bank as the highest bidder. OCA applied for injunction which was granted. Now the issue is whether the right of the respondent bank to foreclose the mortgage had already prescribed. So under the terms, time loan number 43 matured on May 12, 1967. So the tolling of the prescriptive period within which the bank had to file the foreclosure began to run on the said date when petitioners failed to fully pay the time loan. Now on August 12, 1971, respondent bank made an extrajudicial demand upon OCA to settle the time loan. These letters sent by the bank to the petitioners effectively stopped the tolling of the prescriptive period because, respondent bank made an extrajudicial demand upon OCA to settle the time loan. These letters sent by the bank to petitioners effectively stopped the tolling of the prescriptive period because you must remember that when an extrajudicial demand is made, okay, then it effectively tolls the prescriptive period. Aside from the filing of the action, the extrajudicial demand set by the creditor or the acknowledgement by the debtor of the debt, okay, these acts toll or suspend the prescriptive period. It is true that the mortgage actions prescribe after 10 years. However, its running has effectively been interrupted by written demands from the bank as well as the written acknowledgement issued by OCA itself. Okay. Now we go to the different periods set by law. Remember that these periods are counted from the time that because of action accrues, meaning that there is the possibility, the legal possibility of commencing the action. Okay? Real actions over immovables prescribed after 30 years. So, with respect to real property, the prescriptive period is 30 years, which is also the counterpart of the acquisitive prescription on immovable property, which is also 30 years in case of extraordinary prescription. Okay, a mortgage action prescribes after 10 years. Okay, so when there is a mortgage, deed of mortgage, okay, if there is a default on the part of the debtor, okay, then you should file the foreclosure, whether judicial or extrajudicial, within a period of 10 years. If you fail to file that action, okay, then the action prescribes. Okay. The following actions must be filed within 1 year. A year, forcible entry and detainer. So, action interdictal. It has to be filed immediately within 1 year from the time that the cause of action occurs. For defamation, okay, there is also a 1 year prescriptive period. So the following rights are not extinguished by prescription. You must remember that with respect to Article 1143, this refers to imprescriptible actions. Okay, so it is not extinguished by prescription to demand a right of way. Because you must remember that in right of way, it is the needs of the dominant owner that is paramount. Okay, so the needs of the dominant owner cannot be predicted. As for now, he may only be a pedestrian right of way may be sufficient, but you will not know later, 30, 40 years after, he may need a wider right of way to accommodate vehicles. So that is the reason why an action to demand a right of way is not extinguished by prescription. Okay, to bring an action to abate a public or a private nuisance, because you will never know when they will arise. That is the reason why the law deemed it appropriate to make it imprescriptible. Okay, Article 1140, actions to recover movable shall prescribe 8 years from the time the possession thereof is lost, unless the possessor has acquired the ownership by prescription for a lesser period. You must remember that with respect to movables, okay, the acquisitive prescription, okay, regardless of good faith, is 8 years. That is also the reason why, with respect to prescription of actions, uninterrupted period of 8 years would be sufficient to consider the movables as already lost. Okay? The following actions must be brought within 10 years from the time the right of action accrues. Okay, when there is a written contract, when there is an obligation created by law, when there is a judgment. Okay, example of an obligation which is created by law would be the obligation not to plant a tree within the required distances from the property line. So if that happens, okay, you have a period of 10 years from the time that that tree is planted within which to bring the necessary action. Okay, or when there is a judgment which is issued by the court, in which case you have a period of 10 years within which to enforce the same. Okay. So the following actions must be commenced within 6 years upon an oral contract or upon a quasi-contract. Okay? With respect to injury to the rights of the plaintiff, example, constitutional rights, which we have discussed in our persons and family relations, it must be instituted within 4 years. Okay, upon a quasi-delict, okay, you have to file it within 4 years. Example would be those which are the result of negligence. Okay. Suits involving for damages involving negligence involves quasi-delicti. So you have to file it within 4 years from the time that the cause of action appears. Otherwise, they are considered as prescribed. You can no longer file it. All other actions whose periods are not fixed in this code must be brought within 5 years from the time the right of action appears. Okay, so this is a catch-all provision. If the civil code did not specifically state the period for prescription of actions, it must be 5 years from the time the right of action appears. Okay, so that is all for prescription. Thank you for listening.